Today I have a video that you will definitely want to see. A few months ago, I covered a case involving a self-proclaimed sovereign citizen. In that video, the defendant claimed to be the beneficiary of an estate and referred to the judge as a trustee. Towards the end of that case, Judge Martin mentioned the next appearance would be before Judge Oakley. For those who don't know, Judge Oakley is someone I have featured on this channel before. He is well known for his no-nonsense approach to courtroom behavior. In one previous case, he firmly dismissed irrelevant and disruptive arguments made by individuals trying to misuse legal terms. Today's hearing involves that same defendant and Judge Oakley. What happens in this session is intense and worth watching. You will see how Judge Oakley handles disruptive behavior with authority and clarity. Let's begin with the hearing and see how the situation unfolds.
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
The case being called is the People versus Frank Michaud Jr. The prosecution is ready, represented by Mohammed on behalf of the state. When the defendant was asked to sit at the defendant's table, he hesitated and raised concerns. His representative attempted to explain, stating that the defendant identifies as a sovereign citizen. The defendant objected to being labeled as such, but the judge instructed him to remain silent until allowed to speak. Judge Oakley made it clear that he does not recognize any distinction between the defendant and a supposed separate legal entity. He emphasized that the court operates under established law and procedures. The judge informed the defendant that if he refused to participate, a bench warrant would be issued. At this point, the defendant expressed feeling threatened. The judge responded firmly, confirming that attendance and cooperation were mandatory.
It's under the barcode, though. This is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode.
Judge Oakley continued to explain that the current proceeding is a scheduled preliminary examination. He urged the defendant to comply by taking a seat, stating that the courtroom would not operate under the defendant's terms. The defendant insisted on reserving all his rights and declared that he would be presenting himself. The judge clarified that the defendant must choose whether to represent himself or accept legal representation. The court-appointed attorney stood ready to assist, but the defendant refused legal counsel. He stressed that the individual present in court was not his attorney and that he did not require one. Despite this, the attorney remained present as an observer in case assistance was later requested. The judge emphasized the risks of self-representation, especially in a criminal matter, noting the importance of professional legal knowledge.
All right, appearances for the People versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have works.
Yeah,
You're on side here.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
The judge asked the defendant if he wished to make a jurisdictional argument. The defendant replied indirectly, questioning why he had to answer with a simple yes or no. Judge Oakley explained that direct answers were necessary to maintain order. The defendant eventually confirmed that he did have a jurisdictional challenge to present. When asked to proceed, he began by questioning the court's authority. He referred to Article 6 of the U.S. Constitution and requested clarification on the type of jurisdiction under which the court operates. Judge Oakley replied that the court functions under the authority of the state of Michigan and is created by statute. The defendant pressed further, asking whether this meant the court was under admiralty or common law jurisdiction. The judge firmly responded that the court operates under statutory law, not admiralty or common law.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here, is through the microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oth to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I have recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
The defendant continued pressing for clarification, asking whether the matter was civil or criminal. Judge Oakley explained that the court handles both civil and criminal cases as provided by Michigan statutes. In this case, the matter was clearly criminal. The defendant argued that under criminal law, there must be an injured party for the charge to exist. The judge stated that the injured party is the people of the state of Michigan. The defendant demanded a sworn statement from the alleged injured party. Judge Oakley informed him that there is a sworn complaint on file as required by law. When the defendant insisted on an affidavit, the judge clarified that the complaint meets the necessary legal requirements. The discussion grew tense as the defendant repeatedly interrupted, prompting the judge to warn him about contempt of court.
Okay.
So, with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
so today,
You have a jurisdictional argument you want to make?
what I've served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or
multiple
no?
why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority
or
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not
order.
admiralty,
What is
and
it?
it's not common law.
Which
It's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
my
record, I need to
jurisdiction
have
is
it
both
on-
civil.
I can't defend myself unless I have it on the record.
Judge Oakley ruled that the court has jurisdiction, allowing the defendant the right to appeal the decision. The prosecution prepared to call its first witness. Before proceeding, The prosecution requested a standard order of sequestration for witnesses. The judge asked a person present in the courtroom to provide their name for the record as they were identified as a potential witness. The defendant interrupted again, leading the judge to issue a contempt finding and a fine of $100. The judge warned that continued interruptions would result in escalating consequences. Despite the ruling, the defendant claimed he did not understand the contempt finding. The judge informed him that his lack of understanding did not change the fact that he owed the fine. This demonstrated the judge's determination to maintain courtroom order.
Is it
My jurisdiction.
It's only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right. So is that common law or average?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed, all,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure
bringing
the
the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
After restoring order, the prosecution moved forward with presenting its evidence. The prosecutor introduced a certified record showing the defendant's previous felony conviction under the relevant statute. The defendant objected but failed to provide a valid legal basis for the objection. He argued that the hearing was supposed to be a probable cause conference, not a preliminary examination. Judge Oakley clarified that the two terms are closely related and often used interchangeably under Michigan court rules. The defendant persisted in arguing about the terminology rather than addressing the evidence. The judge explained that this proceeding was scheduled to determine probable cause for moving the case forward. The defendant continued to question why the case record used different labels for the hearings. The judge attempted to use a simple analogy to illustrate that names may differ, but the purpose remains the same.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
As the defendant continued to argue,
you still owe me $100.
the judge instructed court officers to remove him from the courtroom temporarily. Judge Oakley stated that he would not allow the defendant to disrupt the proceedings further. The court-appointed attorney requested an opportunity to calm the defendant and explained his objection. The attorney clarified that probable cause conferences do not require evidence presentation, whereas preliminary exams do. He further explained that the defendant had missed a prior probable cause conference due to family obligations. During that time, the attorney represented the defendant and obtained approval for his absence, which did not harm his legal position. The judge acknowledged the clarification and emphasized that the current hearing was indeed the scheduled preliminary examination. The court then prepared to resume with the prosecution's case presentation.
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
this is the probable cause hearing.
It says
all right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr. Michaud.
It's still on this,
Mr. Michaud. They're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate columns?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive it?
The hearing resumed with the judge reiterating the importance of courtroom order. Judge Oakley made it clear that continued attempts to derail the process would not be tolerated. The court allowed the prosecution to proceed with introducing witnesses and evidence. The judge also explained that the defendant retained the right to appeal rulings, including jurisdictional challenges, through proper legal channels. The court reminded the defendant that disruptive behavior could result in additional penalties, including contempt charges and possible jail time. Judge Oakley underscored the seriousness of the charges and the defendant's decision to proceed without legal counsel. The judge maintained a firm but fair approach, ensuring that the legal process moved forward despite the challenges presented. The session highlighted how courts handle individuals who attempt to misuse legal arguments to avoid accountability.
Because if this is a hearing, or
You
a conference,
didn't
right,
waive it.
so
There's nothing
so
to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's no
to prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
it still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he gets to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay,
criminal.
listen. You can't tell me something and then just disagree with me and think. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run.